Hello viewers, in our earlier lesson we discussed the concept of negotiation and mediation. Today we are going to discuss the lesson Introduction to Law of Arbitration in India. The objectives of this lesson are to understand the need and significance of arbitration, to discuss the meaning, definition and different kinds of arbitration, to study the development of law of arbitration in India. A society cannot remain static. It keeps on changing with economic, scientific and technological developments. According to social requirements, the law also has to adapt itself and keep on evolving. The globalization and liberalization of economic policies and drastic economic reforms have led to a free market economy in many countries including India. These policies are based on the principle that government control has to be either removed or liberalized in order to allow a free flow of foreign investment and transfer of technology. In this scenario, business and commerce is growing at a rapid pace. Along with it, domestic and international commercial disputes are also increasing. But businesses cannot afford to resolve these disputes through litigation, as it involves complexity of laws, prolonged time frame, protracted and confusing procedures, lack of confidentiality, and even judicial outcomes are inconsistent and indifferent. As such, commercial establishments have moved away from litigation towards ADR. Among all the methods of ADR, arbitration has become globally popular as it is flexible, speedy, cheaper and provides final and binding decision. Therefore, to avoid disappointment to arbitrating parties, it is essential to retain these unique features of arbitration and ensure that arbitration process does not become the mirror image of litigation system. Let us now look at the meaning and definition of arbitration. According to O.P. Malhotra, arbitration is a mechanism for resolution of disputes which takes place usually in private, pursuant to an agreement between two or more parties, under which the parties agree to be bound by the decision to be given by the arbitrator, according to law, or if so agreed, other considerations, after a fair hearing, such decision being enforceable at law. It is private, generally informal and non-judicial trial procedure for adjudicating disputes. According to Halsbury, arbitration is an agreement made by two or more parties between whom some difference has arisen or may thereafter arise, whereby they opine another person to adjudicate upon such dispute and agree to be bound by his decision. Characteristic of arbitration is that it is a private tribunal chosen by parties. According to P. M. Bakshi, arbitration is settlement of private dispute not by ordinary courts of law, but by a private or domestic tribunal. From these definitions, it can be observed that there are four core components of arbitration, that is, an arbitration agreement, a dispute, a reference to a third party for determination, and a binding award by a third party. Section 2, subclause 1 of Arbitration and Conciliation Act 1996 does not clearly define the term arbitration. It is the mirror image of Article 2, subclause 2 of UNCITRAL model law and states that arbitration means any arbitration, whether or not administered by a permanent arbitral institution. It indicates that the Act applies to pure ad hoc arbitration and to have any type of administered or institutional arbitration. We will now examine who is an arbitrator and what disputes are arbitrable. The Indian law does not lay down any specific qualifications for arbitrators. Every person who is of age of majority and of sound mind can be appointed as an arbitrator. Generally, persons who are experts in subject matter of dispute, independent, impartial, and do not have any vested interest are appointed as arbitrators. Regarding arbitrability of dispute, the general principle is that every civil or commercial dispute, either contractual or not, is capable of being adjudicated and resolved by arbitration. But actions in rem which pertain to rights against the world at large can only be pursued in a court of law, while other actions in personam which pertain to rights and interests of the parties between themselves may be brought before a private forum like arbitration. The Arbitration and Conciliation Act does not specifically provide for non-arbitrable classes of dispute, but sections 34 subclause 2 subclause b and 48 subclause 2 of the Act state that an arbitral award dealing with a non-arbitrable subject matter could be set aside. Some examples of non-arbitrable matters are disputes relating to criminal offences, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody, guardianship matters, insolvency and winding up matters, testamentary matters like grant of probate, letters of administration and succession certificate, eviction or tenancy matters governed by special statutes. Let us see the advantages of arbitration. In an arbitration, the parties have the freedom to appoint an arbitrator of their choice, which enables the parties to have their disputes settled through a person of specialized competence and expertise in the relevant field of dispute. The arbitral award is final and binding on the parties and enforceable as decree of the court, and is subject to challenge only on limited grounds. It is most suitable for disputes of international nature, as the law of arbitration has become harmonious worldwide. The arbitral awards are better recognized and enforceable internationally than the court judgments. The parties have the liberty to choose the time and place of arbitration, language of the proceedings, procedure to be applied, and also have legal representation through an advocate. The arbitration process is flexible with regard to time and procedure. It is speedy and economical compared to the court litigation. The privacy and confidentiality of the proceedings is maintained. The parties are at liberty to resolve the dispute through conciliation or mediation during the arbitration proceedings also. The arbitral process is not cumbersome and technical like the court, and it is not difficult for the parties to understand and participate in it. We will now go through different types of arbitration. Arbitrations are classified into different types depending upon the terms of arbitration agreement, subject matter of the dispute in arbitration, and procedures followed by such arbitrators. There is no prescribed standard for classification of the types of arbitration. However, it is universally recognized that arbitration can be broadly classified into two categories: domestic arbitration and international commercial arbitration, which we will be dealing in detail in our next lesson. Apart from this, arbitrations may be basically classified into ad hoc, institutional and statutory arbitration. Ad hoc arbitration. Ad hoc is a Latin term which means for this, that is created or done for a particular purpose as necessary. In ad hoc arbitration, the parties have full liberty and they appoint an arbitrator and decide the time, place, language, process and fees of arbitration for the settlement of their dispute. Institutional arbitration. Under this, the parties agree to refer to settle their dispute or differences through arbitration administered by a particular institution. Such institution has its own procedure and rules. It appoints arbitrators from amongst the panel of experts available with it, with the consent of the parties. For example, Singapore International Arbitration Centre, International Centre for Alternative Dispute Resolution, Indian Council of Arbitration, London Court of International Arbitration, etc. Statutory arbitration, where arbitration is statutorily imposed on the parties and it is obligatory and binding on the parties to refer to arbitrator for settlement of their disputes. It is called as statutory arbitration. For example, Indian Trusts Act 1882. We have already discussed the history and evolution of ADR in our second lesson. In this lesson, our discussion would be confined to development of law of arbitration in India, Arbitration Act 1940, Arbitration and Conciliation Act 1996 and Arbitration and Conciliation Amendment Ordinance 2015. Arbitration Act 1940. This act repealed and replaced the Arbitration Act of 1899 and came into force on 1st July 1940. It dealt with domestic arbitration and was based on the English Arbitration Act of 1934, whereas international commercial arbitration and enforcement of foreign awards was governed by Arbitration Protocol and Convention Act 1937 and Foreign Awards Recognition and Enforcement Act 1961. Let us examine the basic features of Arbitration Act 1940. The Act designed a three-tier system for arbitration, that is, arbitration without court intervention, arbitration with court intervention in pending suits, and arbitration with court intervention in cases where no suit was pending before the court. The first schedule of the Act provided implied conditions of arbitration agreements, and the second schedule provided powers of the court in arbitration proceedings. The written agreement under this Act means an agreement in writing to submit present or future differences to arbitration, whether an arbitrator is named therein or not. In absence of any difference and an agreement to refer the same to arbitration, there can be no arbitration under this Act. The arbitration award was to be made as rule of the court to be enforceable, that is, the award should be approved by the judgment of the court regarding existence, validity and effect of the award and the arbitration agreement between the parties. The parties could have one or more arbitrators and also an umpire. The court had power to remove arbitrator or umpire and appoint substitute for them in order to ensure that arbitration did not fail by reason of want of diligence or misconduct on part of the arbitrator. No provision with regard to mediation and conciliation was made under this Act. It provided procedure for setting aside of the award and also appeal thereon. Further, appeals were available from various other orders. However, the Arbitration Act 1940 suffered from several deficiencies and loopholes. It did not facilitate quick resolution of commercial disputes, resulted in excessive interference of courts in arbitral process. Most awards were challenged on various grounds and multiple appeals were preferred from the orders. Arbitration resulted in a second round of litigation before the court, and international arbitration was not harmonious with global scenario, which resulted in lot of dissent and dissatisfaction from the stakeholders. The Supreme Court also lamented in Guru Nanak Foundation versus Ratan Singh and Sons that the way in which the proceedings under the Act of 1940 are conducted and without an exception challenged in courts has made lawyers laugh and legal philosophers weep. The proceedings under the Act have become highly technical, accompanied by unending prolixity at every stage, providing a legal trap to the unwary. Further, the Supreme Court in FCI versus Joginder Pal Mahinder Pal observed that we should make the law of arbitration simple, less technical and more responsible to the actual realities of the situation, but must be responsive to the canons of justice and fair play, and make the arbitrator adhere to such process and norms which will create confidence not only by doing justice between the parties, but by creating a sense that justice appears to have been done. The working of the 1940 Act was also criticized in the 210th report of the Public Accounts Committee of the 5th Lok Sabha and the 76th report of the Law Commission of India. In the backdrop of the UNCITRAL Model Law on International Commercial Arbitration 1985 and the UNCITRAL Conciliation Rules 1980, which provide a uniform framework for regulation of arbitration and conciliation, the government was under pressure to amend existing arbitration laws and bring them in line with international practices on the matter. This led to the promulgation of the Arbitration and Conciliation Ordinance 1996 by the President on 16th January 1996 and subsequent enactment of Arbitration and Conciliation Act 1996. We will now study about the Arbitration and Conciliation Act 1996. This Act repealed and replaced the three enactments on arbitration, that is, the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and Foreign Awards Recognition and Enforcement Act 1961. It is based on the harmonized concept of settlement of domestic and international disputes through arbitration and conciliation, majorly adopted from the UNCITRAL Model Law and Rules. The Arbitration and Conciliation Act 1996 was enacted in order to meet certain important objectives like globalizing and reforming the law of arbitration in India to synchronize it with international trends, consolidating and simplifying the law for domestic and international commercial arbitration, facilitating enforcement of domestic awards by treating them as decrees of courts, restricting judicial intervention in arbitration and review of awards to a minimum. Let us look at the basic features of Arbitration and Conciliation Act 1996. The Act governs domestic arbitration, international commercial arbitration, enforcement of domestic and foreign awards, and also conciliation. It is in consonance with the objective to bring out a uniform law in the international arena on arbitration and conciliation, basing on the UNCITRAL Model Law and Rules. It provides for minimizing the supervisory role of courts in the arbitral process. It deals with a wider and more exhaustive definition of arbitration agreement by removing the ambiguities. A separate procedure for disputing the appointment of arbitrators and also on the jurisdiction of the arbitral tribunal has been provided basing on the competence principle, that is, where the arbitral tribunal itself rules on its competence. The arbitral tribunal has to give reasons for arriving at the award. The arbitral award need not be made into rule of a court and would be executable as a decree of a civil court. The arbitral tribunal can use mediation, conciliation or other procedures during the arbitral proceedings to encourage settlement of the dispute. Provisions are made for recognition and enforcement of foreign awards under Part 2 of the Act. For the first time under Part 3 of the Act, conciliation is recognized as a legally valid method of alternative dispute resolution, and the conciliation settlement agreement would have the same effect as an arbitral award on agreed terms on the substance of dispute rendered by the arbitral tribunal. With the passage of time, some difficulties arose in the applicability of the Act of 1996. The conflicting interpretations of the courts in some cases resulted in delay in disposal of arbitration proceedings and increase in interference of courts in the arbitration matters. With a view to overcome these difficulties, the Law Commission of India submitted its 176th report in 2001, and on the basis of this, the Arbitration and Conciliation Amendment Bill 2003 was introduced in Rajya Sabha on 22nd December 2003. The said bill was later referred to the Department related Parliamentary Standing Committee on Personal Public Grievances, Law and Justice for examination. Recommended that many provisions of the bill were controversial and a fresh legislation may be brought after considering its recommendations. Accordingly, the said bill was withdrawn from the Rajya Sabha. We will now study about the Arbitration and Conciliation Amendment Ordinance 2015. The Law Commission further examined the existing Act of 1996 and submitted its 246th report on amendments to the Arbitration and Conciliation Act 1996 in August 2014 and recommended various amendments in the Act for settlement of disputes in a more user friendly, cost effective manner and for expeditious disposal of the cases. As Parliament was not in session, basing on the report, the President promulgated Arbitration and Conciliation Amendment Ordinance 2015, which came into effect from 23rd October 2015. Later, Arbitration and Conciliation Amendment Bill 2015 was passed in Lok Sabha on 17th December 2015 on the same lines, and it is yet to see the fate of Rajya Sabha as on 20th December 2015. The primary objectives of the Ordinance and Amendment Bill of 2015 are to speed up the process of dispute resolution by providing fast track arbitration and giving time limits for appointment of arbitrator, completion of arbitral proceedings and challenge proceedings against the award. To further reduce the intervention of courts in arbitral process, to ensure independence and neutrality of arbitrator by requiring disclosures and providing criteria for ineligibility, to give more authority to the arbitral tribunal for providing interim measures which would be equivalent to the orders of civil court and enforceable accordingly, to empower the Indian courts to provide interim measures even where the seat of arbitration is outside India, to regulate the fees of arbitration by giving a model fee schedule. We will now analyze the scheme of Arbitration and Conciliation Act 1996 as amended in 2015. This Act contains 86 sections in 4 parts and 7 schedules. The Part 1 deals with arbitration, Part 2 deals with enforcement of certain foreign awards, Part 3 deals with conciliation, and Part 4 contains supplementary provisions. Part 1 is the main part of the Act. It comprises sections 1 to 43 divided in 10 chapters, making out provisions relating to domestic arbitration and international commercial arbitration held in India under the Act. It provides for arbitration agreement, interim measures by court, appointment of arbitral tribunal, conduct of arbitration proceedings, recourse against arbitral award and enforcement of awards. An arbitral award made in this part is considered as a domestic award. Further, after the amendment of 2015, the provisions of sections 9, 27, 37 subclause 1 subclause A and 37 subclause 3 shall apply also to international commercial arbitration even if the place of arbitration is outside India, and an arbitral award made in such place is enforceable and recognized under the provisions of Part 2 of this Act. Part 2 provides for enforcement of certain foreign awards. It consists of sections 44 to 60 spread over 2 chapters. Sections 44 to 52 deal with enforcement of New York Convention awards, and sections 53 to 60 deal with enforcement of Geneva Convention awards. Part 3 of the Act exclusively deals with conciliation. It consists of sections 61 to 81 dealing with commencement, conduct and termination of conciliation proceedings, conciliation settlement agreement and also the role of conciliator. Part 4 comprising sections 82 to 86 contain the supplementary provisions of giving effect to the provisions of the Act. The first schedule reproduces the provisions of New York Convention on Recognition and Enforcement of Foreign Arbitral Awards 1958. The second schedule contains provisions of the Geneva Protocol of Arbitral Clauses 1923, and the third schedule contains provisions of Geneva Convention of Execution of Foreign Arbitral Awards 1927. The fourth schedule contains model fee for arbitration. The fifth schedule contains grounds giving rise to justifiable doubts as to the independence or impartiality of arbitrators. The sixth schedule contains form in which disclosure shall be made by the arbitrator when approached for appointment. And the seventh schedule contains relationships for ineligibility to be appointed as an arbitrator. Viewers, from this lesson we have understood the meaning, definition, advantages and basic types of arbitration. Further, we also examined the stages of development of arbitration law in India, specifically from Arbitration Act 1940 to the recent Arbitration and Conciliation Amendment Ordinance 2015. Hope you enjoyed this lesson. We will be dealing with the substantive part of Arbitration and Conciliation Act in the coming lessons. Thank you.